All right, we're back. Love it. Employment Law Show. John Scholes here, and beside me, Lior Samfiru, ready to take all of your questions and answers. You want to reach out when the show's not on air, 1-855-821-5900. help@employmentlawyer.ca, and the website built just for you by Lior. That would be pocketemploymentlawyer.ca. Later on the show today, it's going to be wrongful dismissal fast facts. So make sure you catch some of those. Lior, we always start with the week that was. My friend, how are you?
Hi, John. Always great to be here, and always exciting to talk about employment law and hopefully share some more employment law facts and knowledge. We don't do this just because it's fun for us. It is fun for us, but we do this because these are important and relevant issues that people need to know about. If you have a job, you need to know these things. It's as simple as that. If you're not working, never plan on working, you probably don't care. But if you're working, plan on working, used to work, lost your job, worried about your job, this is the show where we fill your head, hopefully, with some important facts and knowledge that you can use every day. And I want you to spread the word. Tell others about the things that you learn on this show, because your friends, your family, they may not understand these things. They may still believe some misconceptions and could be giving up their rights. So hopefully we can help inform you about what you need to know. And if what we say on this show triggers something, reminds you of an issue, maybe makes you understand that you have certain rights, and you want to discuss those things, please reach out, contact, call, email. We'll give you that contact information throughout the show so that you can do that. But to get us started, John, this week I had a lot of calls from individuals who had a simple question for me. When is enough enough? And what they were talking about is their temporary layoffs. They had been laid off for many months because of COVID-19, like so many others, and they expected to be back to work, but because of closures, opening, they weren't yet called back to work, and their employer initially said, yes, we'll call you back this month and then that month, and they still haven't been called back to work. And these individuals, I spoke with at least 5 of them this week, asked me, well, how long do we have to wait? Yeah. When is enough enough? So here's the thing, John, they actually were asking the wrong question. The wrong question is not, how long can my employer keep me on a layoff? The right question is, can my employer put me on a layoff at all? Can my employer put me on a layoff to begin with? Because for most people, the answer is no. Your employer cannot put you on a temporary layoff, even if it's because of COVID-19. Just by virtue of putting you on a temporary layoff, you have the right as an employee to treat that as a termination and get your severance. That's true whether you're in Alberta, in Ontario, in BC, it does not matter. It's absolutely true. So when you're asking how long can they keep me on a layoff, well, they didn't have a right to put you on a layoff to begin with. So how long? Well, you can say today enough is enough. You could say tomorrow. You could have said that months ago. If you're going to wait for your employer, you could be waiting for many more months. We don't know how long it's going to take us to get out of this pandemic. So yes, you can certainly wait. But the other option that you have as an employee is to say, I am choosing to treat this temporary layoff as a termination of my employment and get my severance now. You don't have to wait. You don't have permission from your employer. You don't need that. You can make that decision. If you've reached that point, where enough is enough for you, you want your severance, you want to move on, you don't want to be waiting, call me. Let's have that discussion. I'll help you get what you're owed. It's not difficult, but you have to make the decision. What is better for you? Sitting and waiting indefinitely, we don't know how long that's going to be. Or saying enough is enough, I want my severance. So the decision is yours.
Another website you can always visit to get a hold of Lior and his crew and his partner as well, Sivan from the Disability Law Show. Employmentlawyer.ca is a great place to go. And from there, you can also search out where to find our radio show, which has been going on for years and years. Lots of phone calls, lots of great information in an hour-long format on the radio. And we like to pull some of the phone calls from those radio shows, Lior, play them back here and pick them apart a little bit. So we'll get to phone call number 1 right now.
I used to work for one of these big corporations in Canada, which is federally regulated. I was there for about 8 years, and I suddenly got an injury. When I got injured, I was out for a long-term disability. The insurance company rejected it, but I was still out because I couldn't even stand or sit or anything. The company just terminated me, and without any severance pay or anything.
John, these types of questions make me shake my head. You know, your heart goes out to anyone that's in that situation. On the one hand, you can't work You've been paying all this money into an insurance policy. Now that insurer is saying, oh, no, you're just not sick enough or injured enough, so we're going to cut you off despite what your doctor says. Your employer hears that, say, oh, well, now we're going to let you go because you're not working. What a terrible situation that is. So let's break this down. First of all, with respect to the insurance company, if you are not able to work, and if your doctor supports you, that's all you need to be off work, and that's all you really should need to qualify for your disability coverage, short-term or long-term disability coverage. Your employer or your insurance company, I should say, cannot disregard your doctor. So if you've been cut off by the disability insurer, or you haven't been approved despite what your doctor says, you need to reach out to my office. We have a whole team dealing just with these issues. We can get the insurance company to do what they are supposed to do. Now, with respect to the second issue, his employer cannot let him go because he cannot work. It doesn't matter what the insurance company says. If you have a doctor's note saying you cannot work, your employer has to give you time off work. If they fire you because of that, it's a human rights violation. If they fire you because of that, they absolutely have to pay you severance. So what I've done also for this person is I took his information and put that in pocketemploymentlawyer.ca, and let's see how much severance this person is actually owed. All right. So we know that this person has been there for 8 years in a clerical role. We see that this person is older, in their 50s. They haven't been paid severance because the employer thinks, oh, we could just let you go without severance because you're not working. Wrong, illegal. You see right at the bottom of the screen there that this person is owed about 10 months severance. 10-month severance. That's from pocketemploymentlawyer.ca, in addition to human rights damages. So this person and anyone else in a similar situation, if you can't work, if your insurance company won't pay you, if your employer does anything to you, you have to call right away.
I noticed in that phone call as well, this person, and this is a term people often get tripped up by, federally regulated or provincially regulated. What's the difference?
Honestly, for our purposes, when it comes to your rights, your severance, the entitlements that you have if you lost your job, there really isn't a difference. Your employer has to pay you if you lost your job. The amount of severance is going to be the same whether you're federally or provincially regulated. The interesting thing is, by the way, for federally regulated employees, in some situations, you may actually be able to get your job back. So that's interesting. But you don't have less rights. You may even, in fact, have more rights. But when it comes to severance, it doesn't matter, federally, provincially, you get the same amount of severance.
Another website for you anytime to ask questions other than the phone call or the email is terminationquestions.com. Lior, I want to get to the first one today from Chantel. She writes in, says, the owner is asking me to retire at the age of 68 after 13 years with the company so they can reduce staff costs to weather COVID-19. If I don't, they said they may have to fire me with 2 weeks' notice. What are my rights?
Oh, my God. John, how do I even begin with this? I mean, it's a short question, but it's ridiculous. Well, yeah, let's start with the age. So your employer can't let you go because of your age, can't demand that you resign because of your age or retire because of your age, and can't choose to let you go instead of others because of your age. It's age discrimination. We don't have such a thing as mandatory retirement. We don't have such a thing as 65, you're gone. We used to have that. It was eliminated in every province many years ago. So if you've been chosen, quote unquote, for termination of employment because your employer says you're older, illegal, human rights violation, can't happen. You can be pressured into retiring. You can work till 95 if that's what you choose to do, as long as you can do your job. Now, the other thing is the employer says, oh, we'll just let you go with 2 weeks severance. No, not possible. Remember, you have significantly greater severance entitlements. This person could be owed a year's pay, 15 months pay, 20 months pay, not 2 weeks pay. But there's a lot of illegal things going on there. But really important to remember, you cannot be picked on, terminated, or pressured to do anything because of your age.
All right, we'll take our first short pause of the show. When we come back, wrongful dismissal, fast facts. We will get to those. In the meantime, 1-855-821-5900 to reach out and help at employmentlawyer.ca. It's the Employment Law Show. Do not go anywhere.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Thanks for hanging around. Employment Law Show. Again, John Scholes and Lior Samfiru. You may have heard this term wrongful dismissal in past shows. We want to whittle down a little bit on it. Wrongful dismissal fast facts is what we're going to talk about here, Lior. So let's get right to them, shall we? First one is this. A wrongful dismissal concerns your severance pay, not how or why you were let go.
That is a huge misconception. The term wrongful dismissal, suggests that the company did something wrong in dismissing you. Well, it's really nothing to do with the circumstances you were let go, why you were let go, whether or not the company should have let you go. That's not a wrongful dismissal. For the most part, John, wrongful dismissal has to do with severance. If you've been let go and have not been paid proper severance, that's a wrongful dismissal. Even if the company had to shut down the department and they let you go because of that, so they clearly didn't do anything wrong there. If they didn't offer or pay you proper severance, that is still a wrongful dismissal. So for the most part, John, when we're talking about inadequate severance, that is what a wrongful dismissal is. Remember, most people, in fact, have been wrongfully dismissed. We'll talk about that in a second. So it's not about why you were let go, and that's because of the fact that an employer generally can let you go at any time and pretty much for any reason, but they have to pay proper severance. That's the big issue there. And most employers either don't want to or don't know how much severance they have to pay. And that's what makes it a wrongful dismissal. The good thing, by the way, it is easy to resolve.
Next fast fact on wrongful dismissal is this. They're quite common, actually, across the country here in Canada.
It's shocking, John, how common wrongful dismissals are. Over 90% of people, 90%,
Wow.
when they have been let go, even if the reason is legitimate, even if they're working for a big company, huge multinational, doesn't matter. 90% of people, when they've been let go, have in fact been wrongfully dismissed in the sense that they're owed more severance. And that is what a wrongful dismissal is. And I'm not even talking about a situation, John, where you've been wrongfully dismissed because you're owed 10 months severance and the company's offered you 9 months. In most cases, it's not even that small a gap. It's you're owed 10 and they offered you 3. So that's why it's so important to get advice the moment you're being terminated, the moment you're staring at that severance letter. Because without even looking at what you've been offered, I will give you a 90% chance, and that's very conservative, by the way, but a 90% chance that you have in fact been wrongfully dismissed. So you reach out to me, you go to pocketemploymentlawyer.ca, we figure out what you're owed, and then we do what we need to do to get you what you're owed.
You know, we're talking about wrongful dismissal fast facts here, Lior and I, today, and this one's very common. You get that severance letter. Oh, Friday at 5, I need that back, and your decision made. No. You have 2 years to do something about that wrongful dismissal, correct? 2 years.
Absolutely. 2 full years. So that's why that deadline, when you're looking, and anyone that's ever looked at a severance letter is going to know what I'm talking about. Yep. That there's a deadline. You have to accept this by Friday at 5 or by Wednesday at 5. And if you don't, we're not going to pay you what we're offering. Well, that deadline is ridiculous because you actually have 2 years to pursue your entitlements. Your entitlements don't go anywhere for 2 whole years. And most employers put that deadline there as a pressure tactic. It's not that they don't know about the 2 years. It's a pressure tactic. They want you to sign so that they can pay you what they want to pay you instead of what you're actually owed. Don't let that happen. But the flip side of this is, John, every single time I do this show, I come on TV and I talk about these things, I get emails. In fact, I'm going to go check my emails after we're done here. And I'm going to have emails from people saying, I've been wrongfully dismissed. And I realize that now. The company owes me a lot more severance, but it happened 3 years ago or 5 years ago. Can you help me? Unfortunately, I cannot. because there's a 2-year limitation period. And if you realize that 2, 3, 5, 10 years ago you've been wrongfully dismissed and you were owed another $100,000 in severance, see that happen often, you can't do anything about it. So don't sit on your rights. If you've been let go, get advice. Don't wait. Don't assume you're not owed anything. Don't forget about it, because if you do, you may realize when it's too late that now you can't do anything.
All right, our next wrongful dismissal fast fact is that these dismissal matters are not difficult or lengthy to resolve.
So it would be very strange if I got on TV and I talked about wrongful dismissal and I said, call me, and it's going to take me 3 years to resolve this for you. That'd be ridiculous. First of all, I would never do that, and why would anyone ever call me? That's simply not the case when it comes to employment law issues, when it comes certainly to wrongful dismissal. Unlike most legal issues, wrongful dismissal cases resolve usually quickly and often without even the need of legal action. Oftentimes we can engage the company with a letter or two and get it resolved. Often it takes 2, 3, 4 weeks to resolve. It's that fast. Now, I know a lot of people have heard stories, my friend's divorce took many years. My cousin's criminal case took many years to resolve. That is true, but that's not true when it comes to employment law. That's not true when it comes to wrongful dismissal. Usually these matters not only are not difficult to resolve, they resolve quickly. So please don't ever avoid your rights or walk away from your rights because you're afraid about the process. You're afraid about what it's going to take to get it resolved. I'm here telling you that in most cases, it's not difficult. Certainly not if you're talking to a lawyer that knows what he or she is doing.
Well, that's the last fast fact that we're going to give today. Is an employment lawyer like this guy can tell you if you have been wrongfully dismissed, so please reach out, right?
Well, I think everyone should, first of all, know if they're owed something. Just the fact that you realize you're owed something more doesn't mean you have to choose to do something about it. You may take that information and walk away, but at least you'll know. And what I don't want to have happen, I don't want to have a situation where, you've always wondered and you've kind of been off and it's always been bothering you. And by the time you actually make the call, because now you really need to know, it's too late to do something about it. So let's at least have a chat about what you're owed. I can always outline it to you, and then you decide, yes, I want to do something about it, or no, I don't. It starts with making a phone call, or even easier. We've said this before. When it comes to wrongful dismissal, just go to pocketemploymentlawyer.ca. You can find out yourself in seconds and anonymously what you're owed. So check it out yourself at pocketemploymentlawyer.ca.
And again, quickly, that phone number anytime, 1-855-821-5900 to get a hold of Lior and a member of his crew. Employmentlawyer.ca, again, is the place you go to find the radio show. Call number 2, Lior, from our radio program is coming up.
This person says they're a subcontractor, and I said they're not a subcontractor. They're working just for you. They want to be called a subcontractor. So what, again, do they need to have to prove that they're a subcontractor, not an employee?
Love this question.
I get this asked very often, and the difference between a subcontractor, also known as an independent contractor, and an employee. So an employee is someone that works usually for one company, not always, but at least most of the time works for one company. An employee is someone that is not in business for themselves. They have a boss, they report to someone, they have regular hours, they have work that is given to them by someone else. They don't generate their own business. They don't go out there marketing their services. So, who is an independent contractor or subcontractor? Think about your plumbers, your electricians. If you call in an electrician because you have an electrical problem, that electrician is not your employee. They're in the business of providing electrical services. They market their services. They maybe, have a website where they market those services, or social media. And after they're done doing the job in your house, they're going to go to someone else's house and do another job. So that's what an independent or contractor or subcontractor looks like. On the other hand, if you have a business and they are working only for you, they come in every day to work on your business, they go home, come back the next day, and that's all they do, well, then that electrician all of a sudden would be your employee. So always ask yourself, are you, if you're an independent contractor, do you have a job, or are you like that plumber, like that electrician? Which one are you? It doesn't matter what you call yourself, doesn't matter what you signed, it doesn't even matter how you file your taxes. If you look like an employee and act like an employee, then you are an employee, and nothing else is going to change that.
Let's take a short break. Lior, got lots more coming up, including waiting to be called back from a temporary layoff. That could be a while. We'll tackle that after the break. 1-855-821-5900 and pocketemploymentlawyer.ca as well. Stick around, coming right back.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Employment Law Show. Yeah, employmentlawyer.ca. That is where you go as well to find a radio program across the country that will suit your needs. And you can listen in for that hour-long program as well. Lots of phone calls every week from different markets. Lior, phone call number 3 from the radio show is coming at you right now.
I've been laid off, and they haven't called me back to work, and they have called some other people back to work. And I just want to know, at what time can I ask for my severance?
How long have you worked there?
18 years.
And what kind of a job and how old are you?
I'm in my 50s, and it was a sales job.
Now.
John,
right
I
now.
told you. Exactly. Well, I told you this at the beginning of the show. I wasn't kidding that this is a question I get asked often.
Yep.
How long? How much longer can I be told that I have to be on a layoff? How long do I have to wait? I don't want to wait. I want to work. I need to work. I have bills to pay. I can't live off EI or CRB because it only pays me a portion of my salary. So how long? Lior, please tell me how long. Well, the answer is now, right now. In fact, it could have been yesterday. It could have been a month ago. It could have been a year ago, because your employer does not have a right to lay you off temporarily in most cases, meaning you can decide. You don't have to wait for the company to decide. You can decide when it's enough. You can decide when you're done waiting. So you can decide now, today, immediately. I am not waiting. I'm now going to say that you've terminated my employment, Mr. Employer, and now you have to pay me my severance. So you don't have to wait. You don't have to worry. You don't have to wonder how long you're going to be off work. You can make that decision. Now, going back to that call that we had on our radio show, let's take his information and plug that into pocketemploymentlawyer.ca so that we can actually see the amount of severance that he's owed. So we know that this person, you see that on the screen, is in his mid-50s, he said. He's in a sales role, and we know that he's been there for 18 years. If he chooses to treat his employment as being terminated, if he chooses to get severance, we see at the bottom of the screen that he's owed about 18 months' pay, 18 months. In fact, it could even be more than that. It could be as much as 20 or 21 months of severance that he would be owed. So that's, even though, John, his employer is not sending him a letter saying, we're letting you go. This is where the employee, he decides to say, I am done. I am choosing to treat this as a termination. So if you're at home wondering, how long can I stay on a layoff? The answer is not at all. You can treat that now, today, right now, as a termination, if that's what you want.
If you've been off for that entire year through COVID up until, say, today, does that time also accrue towards your severance? Say you've been on temporary layoff?
It certainly does, yeah. So time you spend off work does accrue towards your severance, and in fact, it could increase the severance because, of course, the longer you work, i.e. the more seniority, the more service you have, the more severance has to be paid. So yes, it does count towards your seniority.
TerminationQuestions.com, another website you can go to anytime to ask your questions. Yours may pop up here on the TV show, just like Joel's has. Lior, and we'll get to that right now, says, are there separate legal rules or conditions on severance packages for C-suite employees and executives?
Well, there are no separate rules per se, except for the fact that someone in a unique situation, C-suite or an executive, that person may be owed more severance than someone more junior to them because of the fact that the more senior a position you have, the more severance is owed to you. It's assumed, right or wrong, that the more senior a position, the more specialized the position, the more difficult it's going to be to find another job. And that will have an upwards impact on your severance. So generally, yes, executives will get more severance than someone that's not a manager, than someone that's not as a senior position. The other thing for executives to understand when it comes to severance is that severance includes all components of compensation. And that's especially important for executives because we're talking potentially about not just salary, not just benefits, there's bonuses, maybe commissions, car allowance, stock options. We're talking about potentially other entitlements, pension plans, incentives. All those forms of compensation have to be addressed and have to form part of the severance package. Very often employers forget about them or don't include them. That's wrong. That's illegal. That can make it a wrongful dismissal. So when it comes to executives, it's not just the number of months of pay that you're owed. Maybe it's 18 months, maybe it's 24 months, but it's not just that. It's also what's included in it. Remember, you could be owed significantly more than just your salary. A lot of executives have significant bonuses, incentive payments. They may have stock options that could be worth a lot of money, and those have to all be addressed. If you're not sure what needs to be included, or if your employer properly included something, pick up the phone and call me. It could be worth a lot.
You got a couple minutes. I'll get to one more question quickly. Lior comes from Manuela, says, my boss is rejecting all my vacation time requests, saying that he can't accommodate them because of COVID-19. Isn't it up to the employee to choose when they take time off?
You know, John, I've been getting this question so often since COVID-19 started. Yeah. And here's the reality. The reality is that, unfortunately, no. It is not up to the employee to decide when they take vacation. The employer has the legal right to schedule the employee's vacation. In other words, to decide when the employee takes vacation. Now, most employers don't do that. Most employers will leave it to the employee to decide and say, employee, your vacation, ask for when you want to take it, we'll approve it, and off you go. But despite that, employers can choose to say, we've decided now that you're taking your vacation between April 15th and April 25. You may say, well, wait a second, I don't want that. I want to take my vacation in July, not in April. Despite that, the employer is allowed to do that, and not much that you can do. So talk to your employer about that. Try to work something out. But the general rule, maybe unfortunately for many employees, that an employer can choose when you take your vacation, even if it's not the ideal time for you, the employee.
Does it make a difference if they've approved it, you bought plane tickets and hotel reservations, all that stuff, or no?
So I've seen that happen often, actually. So I asked for vacation, the employer approved it. It's a wonderful family, we're going off somewhere, we're going to buy tickets, make reservations. Then the employer says, we've changed our mind, we can't do that. No. If the vacation has been approved, if you've done something in reliance on that approval, you've scheduled things, you've booked things, you've spent money. No, the company can't take it back. The company can't change its mind. So that is a very different situation. And it has happened. Again, I don't suggest you just take off on vacation if it's not approved. Try to work things out with your employer. If you need some help, give me a call. But it's always a bad idea to just say, too bad, employer, I'm leaving anyway. That could potentially cause problems later on.
Moral of the story, when you get approval, book your plane tickets, okay? Just do it. That'll pretty much do it for another week. Exactly. You want to reach out now that we're done, we'd love to get a hold of Lior, 1-855-821-5900. help@employmentlawyer.ca, and the website, pocketemploymentlawyer.ca as well. We'll see you next time, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.